legal analyst, Melusi Xulu, now joins us via video link to weigh in on this case. Melusi, thank you so much for your time. So let's talk about yesterday's arguments. I mean, we saw that they were largely based on the interpretation of Section 47, subsection 1E of the Constitution. Now, the IEC, of course, upheld an objection to Zuma's candidacy based on this particular session, but Zuma's lawyers were clear that the Section 47 did not apply. It got very technical at some point. Just unpack how this section was at the center of the arguments.
Good afternoon, Unat, and to the viewers at home. I think it was very interesting to hear how both parties interpreted Section 47, subsection 1, paragraph E, because the central issue is if you've been sentenced for 12 months, you can't be part of the national parliament, as is stated in the section. However, this case will always come back in such situations, the 2021 conviction and sentence case of the former president. So what the issue is, there was a remission. So the interpretation of remission is what I'm interested on the judgment. Hopefully it will come today, because the MK legal team is saying because of the remission, the 2 months, but the IEC legal team we say, yes, there has been a remission, but the 15 months, the sentence stands. There's nothing that takes away the fact that he was sentenced for 15 months. So I think that's where the issue lies, and hopefully the judgment will clear that up, because if it's not cleared up, Unat, my hope is that it goes all the way to the Constitutional Court, because it started there indirectly, if you will say. So hopefully they'll clear it up.
And then, of course, there was, the other interpretation where, it was discussed in terms of the 5 years that comes into that particular sentencing, when, in fact, that 5 years lapsed. And that also would then, come into that argument. As you rightfully point out, I mean, it is expected that the Electoral Court then does clear this up, particularly because there may be other cases of a similar nature in future.
Yes, I mean, if it's not cleared up in a proper way, for the future, there will be issues, because there's a precedent that is being laid here, and it's about, interpreting the law so that in future we know what will happen. Hence, I'm saying hopefully the Constitutional Courts will clear it up, because I know that when Advocate Ngwaitobi was arguing, he said it's there's two levels of the answer to what you are saying. It could be that the minute he was convicted in June 2021, that's when you start counting the 5 years, or when he finished, whether it's 3 months, as is stated when the remission started. So it's not very clear from his side exactly when it starts, but obviously from whenever they say the sentence was done, it has to be 5 years, which will be in 2027, if I'm not mistaken. But I'm very interested to see how the court will judge when that sentence ends, whether it's 5 years or whether the remission, when the remission happened, that's when the sentence was finished. So it will be interesting to see how the Electoral Courts interprets this 5 years, because I know they spent some time on it.
There was, the lawyers for former President Jacob Zuma, of course, led by Advocate Mpofu, also brought in another section that does not necessarily supersede Section 47, and that's Section 19, which is also contained in the Constitution. Just talk to us about that part of the argument that was obviously trying to bring about its case and give weight to their interpretation.
Yes. If you look at Section 19 of the Constitution, it basically says everyone has a right to start their own party, and everyone has a right to vote for a person that they want to be a president. I think that's the second part of that section. So what Advocate Mpofu is saying is that if the former president is not allowed to be part of the votes or part of be a president, as has been objected. It takes away the rights of the individuals to choose who they want to choose. So I think that's what it's trying to raise. But of course, if we read the Constitution, there's also Section 36, which is a limitation of rights clause, where it says some constitutional rights can be limited. But which will be interesting to see how they interpret Section 19 in relation to that, because it's a constitutional right that has to be respected as well.
Very quickly, in terms of, some of the answer, the response that you gave, particularly in the first question, you said that this may go up all the way to the Constitutional Court. Now, say, of course, that this particular court upholds what the IEC had found. What happens next? Considering, of course, we are in an election year and there are so many dimensions to this particular election, and there is, of course, the IEC timetable.
No, well, the Constitutional Court is obviously the highest court, and there's no other place or court that you can appeal to. So that will be the end of the matter. My reason why I was stating that was because the actual conviction or sentence, whether it was in a civil nature, it was a criminal offense, it was done in the Constitutional Court. And remember, when the former president was sentenced, he was not in court. Now let's go to Section 35, subsection 3, paragraph E of the very same Constitution that says you must be present when you are being sentenced. So there's some unusual things that were done in 2021 in the conviction, and I believe it's coming back to hit us, or to hit the law, if you say that. But if they tell us what was happening, this will be the chance, because the president had been late, and they say it's not usual. Justice Kambebe said this is an unusual way of doing things, but they've done that, and now someone was convicted, but the very same person was not there. Now the former president wants to be a president, but Section 47 is saying he was convicted, but he was not in court when he was tried.